What is arraignment? If you have received a letter from the clerk of court advising you of an upcoming criminal case date in county court, you have been charged with a criminal misdemeanor. The purpose of an arraignment is to advise you of the charge against you, explain your constitutional rights, and for you to enter a plea. You can enter a plea of not guilty, guilty, or no contest. A plea of not guilty means you deny the charge against you. Your case will be set for a future court date approximately 1 month away. For this reason, it is important that you notify the clerk of court if your mailing address changes so that you get future court notices in a timely manner. A plea of guilty means you admit the elements of the crime charged. No contest means you do not admit or deny committing the crime. Instead, you are telling the court that you do not contest the charge. The judge will treat a no contest plea and a guilty plea exactly the same. Sentence will be imposed and the case is over. At the hearing, the assistant state attorney, the prosecutor, will make an offer in your case. As always, you can accept or reject the state's offer. That is your decision. There are assistant public defenders at the hearing as well. If you want to talk about your case with an attorney, you have a right to do that prior to entering a plea at arraignment. If you have a general question, the public defender will be able to answer it. If you want a more in-depth conversation with a lawyer about the details of your case, then enter a not guilty plea, ask for the appointment of the public defender, and they will arrange to meet you over the phone or through a video conference. If you want to hire a private attorney, you may do that at your own expense. Many people who are summoned for arraignment are charged with driving with a suspended or revoked license. If your license is suspended for something that you could fix in the near future, perhaps 60 or 90 days, you may ask the court to continue the case. If you ask for a continuance for this or any other reason, you waive or give up the right to a speedy trial under the rules of criminal procedure. If you are able to get a valid driver's license, the state may reduce or even dismiss the case, depending on your personal driving record. Reduction of the charge is important because this crime can be enhanced, meaning that if it is committed 3 times within a 5-year period, DMV may classify you as an habitual traffic offender, and if so, your right to drive will be revoked for 5 years. If you have 3 convictions for driving with a suspended license in your lifetime, there is a mandatory 10-day jail sentence that must be imposed if you plead as charged. If you are the alleged victim in a criminal case, you have a right to be heard and be present at all critical stages of proceedings, and arraignment is one of those critical stages. The issues that may be addressed at arraignment include whether you want to change the order requiring the defendant to have no contact with you, as well as other conditions of release. Your wishes in the case are an important factor that the state takes into consideration in deciding to go forward with the case, but it is not the only factor. In other words, sometimes the state decides to prosecute the case even if the alleged victim does not want the case to go forward. They make that decision based on factors like the number of times this crime is alleged to have occurred in the past, the degree of violence involved, and their belief that they can prove the case through other evidence and other witnesses. Finally, you should know that there are some crimes that have mandatory minimum sentences, for instance, domestic battery or driving under the influence. The legislature requires parts of the sentence that may include classes, community service hours, or other conditions. If you have any questions, ask the judge or the public defender. It is the judge's job to make sure that you are treated fairly and that you understand what is going on. Although we try to talk to as many people as possible in the shortest time, it is our goal to take as much time as you need so that you understand your options and can make the best choice for yourself under the circumstances. This is your day in court.